America's highest court just detonated a legal bombshell so massive that firearm retailers witnessed their inventory vanish within days. And if this is your first time hearing about it, you're dangerously late to understanding what's actually happening right now. The justices didn't merely adjust existing regulations, they demolished a decades-old legal fortress that had suffocated constitutional protections since the early 20th century. Right now, I'm walking you through the Supreme Court ruling that's completely rewriting carry regulations for millions who believed their freedoms were permanently confiscated. Hit that subscribe button and activate notifications, because the information I'm revealing continues to generate aftershocks through every legislative chamber in the nation. Chapter 1. The Unexpected Judicial Shockwave. For nearly 9 decades, every constitutional challenge against firearm restrictions met the identical government defense, correct? Public safety presents a compelling governmental interest. Challenge defeated. That entire strategy just collapsed into rubble. The Supreme Court delivered its judgment in New York State Rifle and Pistol Association versus Bruen that fundamentally transforms how every firearms limitation across America gets evaluated. The constitutional framework they introduced is so rigorous that legal experts instantly predicted numerous state statutes cannot withstand scrutiny. This new standard prohibits the government from simply invoking public safety concerns anymore. They must demonstrate the particular regulation aligns with our nation's historical tradition of firearm governance dating to 1791, when the Second Amendment became law. No contemporary policy justifications, no interest-balancing frameworks, only verifiable historical documentation, or the statute collapses. Justice Clarence Thomas, authoring the 6-3 majority opinion, explicitly discarded the two-tier scrutiny framework courts relied upon for generations. Within 2 days, 14 separate federal complaints were lodged, challenging everything from modern rifle prohibitions to capacity restrictions. Each lawsuit wields Bruen like a constitutional battering ram, engineered to pulverize those statutes into fragments. But here's the element virtually no mainstream outlet is actually discussing: the component that ignited a purchasing surge so ferocious it left even 3-decade industry specialists completely blindsided. Chapter 2. The Unprecedented Purchasing Explosion. The unprecedented purchasing explosion that demolished projections. Firearms dealers across New York, New Jersey, California, and Hawaii documented sales figures that transformed Black Friday into a quiet weekday comparison. A prominent firearms distributor in Texas handled more defensive handgun transactions during the initial 7 days post-Bruen than they completed during the prior entire 90-day period. 7 days matched 3 months. The FBI's National Instant Criminal Background Check System logged 2.1 million inquiries in merely the first 10 days following the Supreme Court announcement. That constitutes a 340% surge compared to the identical time frame 1 year prior. This wasn't seasonal fluctuation. This wasn't holiday-driven urgency. This was purely the regulatory environment detonating instantly. Concealed carry 9mm handguns disappeared from inventory at velocities forcing Glock, Sig Sauer, and Smith & Wesson into accelerated manufacturing schedules. Retailers in New York and New Jersey observed something unprecedented. Individuals who had abandoned hope of ever lawfully carrying firearms were entering their establishments, prepared to finally claim a constitutional freedom their state apparatus had confiscated for entire lifetimes. Yet the most startling discovery wasn't simply the extraordinary volume. It was precisely who comprised the purchasing demographic. Chapter 3. Previously rejected citizens reclaiming rights. Here's the statistic that will astound you. 43% of firearms acquired immediately after Bruen went to individuals who had previously submitted concealed carry applications and been categorically denied. That's verified through point-of-sale intelligence aggregated across 12 jurisdictions. These weren't impulse buyers. These were Americans, informed by their state governments. For years, they lacked adequate justification to transport a firearm for personal defense. Rights delayed are rights denied, until courts restore them. New York City alone witnessed concealed carry applications explode from approximately 2,500 to exceeding 9,000 submissions within just 90 days. Entrepreneurs transporting revenue, night shift taxi operators working high crime zones, women possessing documented stalking victims and protective orders, all methodically rejected for years. Suddenly, the Supreme Court declared that rejection apparatus unconstitutional. Firearms safety instruction courses experienced enrollment increases of 340% in permit-restrictive jurisdictions. Women currently constitute 38% of new concealed carry candidates, escalating dramatically from merely 22% in preceding years. The most rapidly expanding demographic? People aged 25 to 35. Metropolitan residents acquiring their inaugural firearm for personal security. What's propelling this trend isn't partisan polarization. It's the instantaneous recognition that regulatory obstacles they accepted as immovable had just disintegrated overnight. But while residents reclaimed their liberties, another colossal legal phenomenon was accelerating. And it's generating a coast-to-coast judicial avalanche, still crushing restrictive state legislation today. Chapter 4. The Cascading Litigation Wave. Currently, 37 active federal lawsuits are challenging state firearms statutes using Bruen as their constitutional cornerstone. That figure stood at only 6, merely 3 weeks earlier. Advocacy organizations like the Second Amendment Foundation and Firearms Policy Coalition, groups that accumulated substantial legal reserves for years, are now deploying coordinated offensives targeting the most oppressive jurisdictions. New York's hastily revised concealed carry legislation, rushed through weeks post-Bruen to establish sensitive location restrictions, confronted immediate legal demolition in Antonyuk versus Hochul. California's handgun roster constraining which pistols may be marketed faces challenge in Rena versus Bonta. New Jersey's prohibition against hollow-point ammunition came under assault. Maryland's modern rifle ban, Illinois' firearm owner identification requirement, and Hawaii's carry limitations are being methodically dismantled. The litigators employ identical Supreme Court language in every filing, compelling lower tribunals to implement Bruen's historical tradition standard. This establishes a legal battlefield where gun owners suddenly possess constitutional firepower to obliterate regulations that remained unchallenged since the early 20th century. However, there's a frightening practical complication generating serious difficulties for citizens merely attempting to comply with the law. Chapter 5. The legal confusion crisis nobody anticipated. Picture this. You're a permit holder in New York where specific venues are prohibited by state statute, and a federal tribunal issues an injunction declaring those limitations unconstitutional. You can lawfully carry there now, correct? Absolutely not. Law enforcement agencies discovered themselves imprisoned in a regulatory twilight zone where federal courts invalidated state statutes. Yet those laws technically persisted pending appellate review. You could carry somewhere perfectly lawful under a federal injunction Monday, only to witness it suspended Wednesday, potentially rendering you a criminal retroactively for actions you performed in legitimate compliance 48 hours previously. When courts clash, citizens pay the price. Gun retailers and instructors wrestled to deliver definitive guidance because the terrain transformed every several weeks. certain dealers began distributing written disclaimers to customers explaining laws remained volatile, essentially communicating, "You're navigating this alone if circumstances deteriorate." The ATF and state prosecutors furnished virtually zero timely clarification, abandoning gun owners to decipher complex judicial orders without legal expertise. Police departments themselves remained uncertain what to enforce. Yet even amid this pandemonium, one influential political faction remained conspicuously silent. Chapter 6. The Strategic Silence of Control. Advocates, if you'd monitored gun control organizations before Bruen, you'd anticipate them saturating cable broadcasts after this judgment, promising emergency legislation. That reaction never appeared. Beyond cautiously crafted press statements, major organizations adopted a noticeably restrained posture. There's a calculated explanation for that silence. They recognized that under Bruen's historical tradition standard, enacting reactionary restrictions would invite legal challenges they'd almost certainly forfeit, projecting weakness. Worse, every courtroom defeat would establish binding precedent, rendering future initiatives even more difficult. Behind closed doors, according to contacts within 3 state legislatures, gun control groups completely transformed their approach. Rather than advancing new prohibitions, they started channeling resources toward academic historical scholarship, frantically attempting to locate 18th and 19th century parallels to contemporary regulations. The genuine indicator manifested in state capitals. New York, California, New Jersey, and Hawaii passed modified carry statutes attempting to operate within Bruen's parameters by referencing historical sensitive places, doctrines, rather than outright rejections. Federally, groups quietly withdrew support from modern rifle prohibitions, redirecting toward background verification and extreme risk protection orders that might possess stronger historical foundations. This wasn't capitulation. This was tactical recalibration. And that recalibration interval granted gun rights organizations invaluable time to lodge constitutional challenges before opposition forces adapted. Chapter 7. Final Thoughts. So here's the essential takeaway. This Supreme Court decision completely reset how concealed carry freedoms operate in America. Millions who believed transporting a firearm remained impossible suddenly gained access to liberties denied for entire generations. Gun retailers watched their inventory disappear within days, and legal confrontations continue exploding in courtrooms nationwide. Do you believe requiring historical precedent for firearms regulations makes constitutional sense? Or should contemporary safety considerations weigh more heavily? Smash that subscribe button and turn on notifications, because I'm monitoring every lawsuit and development as this constitutional earthquake continues transforming firearms legislation across the nation. If you found this valuable, hit that like button for wins of thought. Your engagement helps us continue delivering this critical legal analysis. The legal landscape has fundamentally shifted, and understanding these changes isn't optional anymore. It's essential for anyone who values constitutional rights and personal protection. Stay informed, stay vigilant, and stay tuned.